also, there are certain unique aspects of the Constitution 2010 that we must bring to the attention of everybody, just in case we've forgotten, because the Constitution that we retired, the Lancaster Constitution, now the former Constitution, was a document that was written by a select few people. It was written in Lancaster, and brought to Kenya. And over the years, it suffered what many called mutilation, because there were several amendments that were made to it, and majority, if not all the amendments that were made to the initial constitution that Kenya had were for consolidating power and insulating the leadership, the political class, from inconvenience of the law, so that for them, where the law was a barrier, instead of doing what the law required, they amended the law to do what they felt, such that they literally dismantled the architecture of the Constitution for the purposes of consolidating power to individuals, and particularly individuals that were in the political class, so that they, as in essence, were the law. And despite us being a republic, the country didn't really act as a republic, but more like it was the leaders who said what happened, and that was the law then. However, the 2010 Constitution is a consensus document. It's a product of works that were produced over a period of about 22 years, and encompasses views and recommendations from a very wide cross-section of Kenyans who said how they wanted to be governed, the kind of Kenya that they wanted, their vision. So the Constitution 2010 is not just people sitting in a room. We had so many initiatives during the demands, the struggle for a new constitution, that built to now the 2010 Constitution. And it was Kenyans who were saying how they want to be governed. So it's important to understand that this is really a consensus document by Kenyans for Kenyans. And so women were a central part of this process. And so the Constitution, among the things that it does, which the former Constitution didn't do, was to recognize women as bona fide citizens of the Republic and grants them presence and existence in our society, giving them equal rights as men. So it is a celebrated and valued covenant, especially among women, because there are many things that women really could not do under the old Constitution that they are given the rights to now. And so we must understand the architecture of the 2010 Constitution, and it's a very comprehensive framework for the transformation of the nation, and puts the citizen at the center. And the citizen is all citizens, because we must remember that women are citizens of this republic, and it has elaborately captured the rights and responsibilities and entitlements in the Constitution, particularly in the Bill of Rights, and puts the responsibility on the state to ensure that the citizen enjoys their rights to the fullest extent possible. So the judiciary also has a very central role as interpreter and enforcer of the Constitution, where the duty bearers, fail us. And the duty bearers are seen as servants. They are servants of the people with a clear prescription on how they are supposed to hold and execute public office, how they are to conduct themselves both publicly and privately, as provided for in Chapter 6 on leadership and integrity. And it declares, as Waikwa said, leadership is a public trust and it's delegated authority that they exercise on behalf of the sovereign, who is we the people. So this is something that we really must celebrate, because the kind of pushback that we are seeing when citizens are exercising their right and they are being called criminals, and they are being called, it is being said enough is enough. It's the machinery of the state is being used against the citizen. What then these institutions of government are doing is actually unlawful, because citizens have a right to exercise their rights, their sovereign power directly. So it's important to understand that. And then now when we come to now the role, and of course, because today we're talking about, the 2/3 and the initiative to dissolve parliament, the Constitution is very deliberate in amplifying the role of women, but not just women, youth, persons with disability, also known as previously marginalized groups, right? And the Constitution, in terms of governance, designates women, youth, persons with disability, marginalized groups as drivers of change, also, contributors and drivers of change. And so the centrality of women and youth and persons with disability it remains a dominant theme in the Constitution. So when we talk about not more than two-thirds gender principle, it's a dominant theme within the Constitution, and it is part of the quest for to remove that raw power and individualization of power, and the way it is exercised, which is usually at the discretion of the leader, the political leader of the hour. So because they are the ones, they see themselves as being the ones who determine how power is accessed, how power is exercised, at the expense of the sovereign or the governed, at the expense of the sovereign, who is we the people. And we know that because women have been used as a very powerful source for the mobilization and organizing for the ballot. Whenever people are vying for office, bring me women leader, women guild. What they know, women are good at organizing, but beyond the ballot, they have no pride of place. And so it's important to understand that the Constitution is deliberate about reversing that marginalization and exclusion. And so this I'm just giving that as a background so that we can understand that the 2010 Constitution is organized around the ideology of inclusion and participation and co-ownership of the political decisions that are made, which is why we have public participation. So I'm just giving this background, not to rant on and on, as a civic education, but really just to say that when we talk about the two-thirds gender principle, it's a central theme of the Constitution 2010 that you cannot have more than two-thirds of any gender in any elective or appointive body. You must bring in the people. And it's important to understand that Article 100 settles that issue and gives that clarity and certainty that participation in governance and decision-making processes must be established by law or has been established constitutionally, and there must be an enabling law for it to happen, which is why when the AG in 2012 sought an advisory about the two-thirds, the Supreme Court gave the timeline within the fifth schedule for the implementation on representation of the people, which was specific to Article 100, that Parliament must enact legislation for the participation of women, youth, and persons with disability in Parliament. It says in Parliament. But when you look, you can see this theme everywhere. It is not more than two-thirds, not more than two-thirds. Now, the other thing that the Constitution has done in Article 261, which is the article that now provides for citizens, anybody can then go to the court when Parliament fails to enact necessary legislation. They can approach the courts to seek the court's intervention for the courts to give a determinate time within which Parliament must enact that legislation, failure to which anyone can then petition for the dissolution of Parliament. Why? This is an enforcement mechanism, given the practice that has been there previously, where we have a political class and a legislature that pretty much does as it feels like, as it wants to do. And we are seeing this. But now this is a corrective measure to enforce constitutionalism, so that for as often as they don't put in the necessary legislation, then citizens can go to court and dissolve Parliament, ask for the dissolution of Parliament as many times as it will take for them to put in the law. And so people must understand that if the rule of law matters, then the not more than two-thirds gender principle matters. If the not more than 2/3 gender principle does not matter, then the rule of law does not matter. We cannot have it both ways. And I think it's important to say this and to know that actually the Constitution 2010 has given us all the necessary tools that we need to enforce to ensure that the Constitution is not breached. And so the dissolution of Parliament is a very valid avenue by which Kenyans can ensure that that delegated authority that is being exercised by parliamentarians, if it is not used to do what is required, then we can send them home. So it is a type of a recall clause, if you like, And I want to say this, that to remind people that when you look at what is happening in Kenya today, the economic crisis that we are facing right now, that too is rooted in failure to adhere to constitutional principles, the principles of public finance management. And so we find ourselves dealing with a rogue house. So let me just I will pause there and allow for Betty to come in. Over.
Thank you. I think it's also really important what you've told us, Daisy, and to remind people that while the litigation has happened on 2/3 on women, because Article 100 actually specifically specifies women, persons with disabilities, youth, ethnic and other minorities, and marginalized communities, and none of these laws have been enacted, there actually are multiple bases for seeking the dissolution of Parliament, because all of those laws have not been enacted, even though so far the public interest litigation has been around women. So just to clarify that as we move ahead. Betty?
Thank you. Can you hear me now?
Yes.
Excellent. Okay. So with regards, I think also it's nice that I'm ending up coming after Daisy, because it's like her contribution is a great place to jump off from. So why we are pushing for this now? As Daisy had mentioned and Marilyn had mentioned, the cases on the 2/3 gender rule are the ones that have been had and determined until the end. So they are the ones that we can jump off to get rid of our National Assembly. But why, and our Senate actually. So both of them, Parliament is the National Assembly and the Senate, yeah? So why we did this is because the Parliament it's gone rogue. It's no longer representing us. If you look at the Finance Act 2023, Finance Bill 2024, if you look at the Appropriations Act, the supplementary appropriations, like consistently, and even before that, yeah, because there was the livestock bill, like if you look at the bills that Parliament has passed, even the IEBC bill, like it has consistently been passing laws that are not serving Kenyans. And then it has been supporting decisions that have not been serving Kenyans. For instance, on the 25th of June, when the president decided to deploy the army nationally, yeah? And then Parliament, despite being on recess, had already post facto ratified it by the next morning. It's just like, that's not how the process works. Parliament needs to approve it first and then it goes. You can't do it and then go and ask Parliament to come back and now ratify it now after the fact, yeah? So we have a rogue Parliament and they're not looking after Kenyans and they're not looking after our interests. So the question we asked ourselves was, constitutionally, what are our options? So when you look at the recall process, Waikwa and Daisy and Marilyn have talked about it. The recall process is it's a multi-part process, yeah, and some of it requires the IEBC to actually be there, and we don't have an IEBC, yeah, because 4 commissioners resigned in protest at the end of 2022, and then the remaining 3 retired in January 2023. So we don't have a commission. An IBC rather. When I say commission, I mean IBC. So we don't have an IBC, and therefore we were looking for a way that we can get rid of Parliament constitutionally without needing the IBC. So then we went back and looked at what are the records, and that took us now to where Daisy is coming from in terms of what is the history of our constitution. Our constitution envisioned a robust, diverse Parliament, and it required the National Assembly and the Senate, both of them, to pass laws to make sure this happens, so that we have, as is being explained, representation of persons with disabilities, representation of youth, representation of women in both the Senate and the National Assembly, and it's meaningful representation, not the tokenism that we are seeing now, meaningful representation, yeah? So we were like, okay, so the Constitution under Article 261 provides this process. And because of the cases that were being litigated, so Daisy is part of Crown Trust, and Crown Trust were one of the petitioners in both the cases that went to court about the 2/3 gender rule. And yes, we realized we actually have a court order that says that we can go and ask for the dissolution of parliament. We don't need IBC, we don't need anyone else. The Chief Justice just needs to tell the president to dissolve parliament. And given all the other challenges that we are facing in the country, we're just like, that's the simplest option we have now. So can we push for it? And yeah, so basically that's the history of it. The fact that we are frustrated with this parliament. They are not serving us. They're not representing us. We have an issue where, like, on the 19th of June, and for me, I was very concerned that this didn't get more airtime. When Kenyans were protesting the finance bill, initially, 18th, 19th June, this bill that had already gone through the first reading, and that's like, if you look at the legislative process in the Constitution, you can't stop things in the middle of the parliamentary process. But the finance bill had gone through the first reading. Then the president calls members of parliament to the State House to inform them of the changes that are happening to the law, and then they come back and sit for a second reading. Like, that was entirely unconstitutional. And for me, that was a final nail in the coffin to show that literally our National Assembly has no backbone. It's at the whim of our president, and that's not what our Constitution envisions. Our Constitution envisions, I don't know how many of us remember this analogy we were given in school, that the government of Kenya is like a stool. One leg is a three-legged stool. One leg is the judiciary, one leg is the legislature, one leg is the executive. So the courts, the parliament and the National Assembly, and the president and the cabinet, and etc. So if any of the legs of the stool are not working, then the stool topples. And for me, that stool finally, like, fully toppled that day when the National Assembly went to be told between the first and the second reading what changes they need to make to our law. I was just like, no, that's not okay. So, and all the other things that we've been seeing. So that was the history, the combination of the fact that, one, we're in a constitutional crisis because we do not have an independent National Assembly, we do not have an independent Senate. And therefore, laws are being passed in a way that's not representing the realities or the challenges of Kenyans. And these people are making decisions, even budgets are being passed in a way that doesn't represent the reality and the challenges of Kenyans. So we're just like, what is a legal way that is a fast and efficient way to do this, that requires very little interaction with government bodies, at least in step one. And the solution under Article 261 met that criteria, because the process is very simple. We remind the CJ that under Article 261 7, she needs to tell the president to dissolve parliament, and that's it. We don't need to draft anything. We don't need to pay any money. We don't need to collect any signatures. And yeah, that's why, like, and I think I'm jumping into the question that was asked by Daisy, but like, for me, I felt that the solution is so much simpler because of that. We don't need to pay the money. We don't need to collect the signatures, but it's still a very constitutional and a very legal process, so that we as Kenyans can continue to live in our constitution, even when our government has decided to live outside it. I think that's it from me. I can hand over back to Marilyn.
Thank you, Betsy.